The next point, we should ensure whatever we see is clear.
That means work is being done, and we can see that it is in opposite direction.
Hello, viewers and learners at home. My name is Yari Zakaria, your Commons teacher. I welcome you again to another e-learning organized by Kaduna State Ministry of Education. Our subject today is Commons. The topic is Law of Agency. Remember, in our previous lesson, learners, we treated Law of Agency. And under the Law of Agency, we have treated meaning of an agent, meaning of agency, types of agency, and also we also look at the duties, rights of an agent and the principal. Today, we shall be looking at appointments of an agent and termination of agency. Appointment of an agent, or what we call it, creation of an agent and termination of agency. Before we look at our topic proper, let us go back and look at what we have done so far in our previous lesson. In our previous lesson, we defined an agent. And by definition, we said that an agent is someone who is employed by another person known as a principal to act on his behalf. Then, agency, as we defined in our previous lesson, an agency, it is a legal relationship that exists between two parties. When one call a principal, employ another person called an agent to enter into a legal relationship with the third party. And we also talk about the types of agents. Types of agents. And some of the types of agents we treated in our previous lessons are 1. General agents. 2. Universal agents. 3. Delcride agents. 4. Auctioneer. 5. Jobber. And so on and so forth. Today, we shall be looking at the following: appointments of agents, or what we call it, creation of agents. The second aspect is conditions for termination of agency. Condition for termination of agency, and summary, and the last thing is assignments. Now, let's look at the first one, appointments of agents. Appointing of agents or creation of agency may come to existence as a result of the following ways or methods. Under the appointment of an agent, we shall be looking at the beginning, or how the principal will come into a legal relationship with another person known as an agent. Now, some of the ways through which an agent can be appointed by the principal includes: 1. Expressly. 2. Necessity. 3. Ratification. 4. By implication. And the fifth one is estoppel. We shall be looking at these methods one after the other. An agent can be established or can be created by express, or what we call it, expressly. This arises when an agent is appointed verbally or in writing by the principal. The agent can now enter into a contract on behalf of the principal. If a principal appointed someone to act on his behalf, either by written form or in a verbal way, such appointment is what we call it express appointment of an agent. It means an agent was appointed expressly. an agent can be appointed by the principal is by necessity. By necessity. Agency by necessity arises due to emergency situations which require some actions to be taken to prevent too much damage. Too much damage. It is a situation that somebody who is in possession of someone's property has to do something to prevent the property from being destroyed. This should be because of reasonable circumstances that warrant this, and the fact that it was not possible to obtain permission from the owner. An agent can be appointed through this method known as necessity. There are some situations that will make someone to act on your behalf even without your permission. There are circumstances that may compel someone to act on your behalf even without your permission. The reason it is because he wants to prevent your good from being what? Damaged. At that very material time, he does not need to ask for your permission before he will act on your behalf. This method is what we call it agency by necessity. The person who has now become the agent must have acted in good intention. For example, in an emergency situation that might damage the goods. Now, let us look at the third way through which an agent can be nominated or can be appointed. That is, an agent can be nominated or appointed by what we call it ratification. Ratification. This occurs when somebody purport, that is, falsely claims to be making a contract with a third party on behalf of the principal to bail such a person out of legal liability, called breach of warranty of authority towards the party. By ratification, it means somebody is acting on your behalf without any official approval. When you come to realize that there is someone who is acting on your behalf without your approval, what you need to do as a principal is for you to what? To ratify the person officially, giving him the authority to act on your behalf. By this method, it is what we call it agency by ratification. The purported may ratify warranty of authority. That is, a person may profess to act as an agent, whereas he has not been so authorized by the alleged principal. By this action, the false agent is converted into an actual agent. Remember, learners, from the beginning, there was nothing like agency. There was nothing like agency between you and that person. But that person, called an agent, choose or decided to act on your behalf without your word, official approval. When such person acts on your behalf without your official approval, by the time you realize that there is somebody somewhere who is acting on your behalf, as a principal, you have no option than to declare him your agent officially. Now, let us look at the fourth one. An agency can be appointed through what we call it implication. That is, agency by implication. This happens when somebody is placed in a position whereby it is a normal and expected that such a position or office holder should enter into a certain contract on behalf of the person appointing him. Like in the case of what we call it universal agent. We say that a universal agent has no limited power. He has unrestricted power. He can enter into what? An agency on behalf of the principal in all circumstances. When someone is being placed in your office, you employ somebody to work, even without telling that person to act on this. If such person choose or decided to act on your behalf on a particular business, such a person becomes your agent. Such is another way through which an agency can be created. Now, this means he has automatically become the agent of the person that appointed him, despite the fact that he was not given express mandates. In that case, an agent, that person was not given what? An express mandate to act as an agent. So an agency can be appointed through that means. Now, let's look at what we call it estoppel. Estoppel, that is the fit or the fit way through which an agent can be created or agency can be created. By estoppel, it means when somebody by conduct or words allow another party to believe that somebody is acting as his authorized agent, even where no agency was intended, he will be estopped from denying the agency if the other party relies on such representation. Somebody by conduct may choose to act on your behalf. The situation that happens between a man or a husband and a wife that are not separated. A wife may choose to act on behalf or a wife may choose to act on behalf of her husband, even without the permission of the husband, telling her to do these things on my behalf. In case of a partnership business, be it a dormant partner or a sleeping partner or an active partner or a nominal partner, such partners in a partnership can decide to act on behalf of other partners. And from that situation, other partners cannot prevent. When we're talking about estoppel, it means you cannot withdraw the word that have agreed upon. You cannot prevent. You cannot withdraw the statement that somebody have said. If your wife chooses to enter into a contract or your mother chooses to enter into a contract on your behalf as a son or as a daughter, and such an act has been performed, you cannot prevent him or prevent her from entering into such a contract. For example, every partner is deemed to be an agent of partnership. Husbands and wives who are not separated, as was in the case of Spiro and Linton, 1993. Linton owned a house and allowed his wife to induce Spiro to buy it, although he did not give her the authority to sell the house. Spiro started carrying out some repairs on the house, even as Master Linton denied that his wife had authority to sell. Now, in this case, the wife decided to act on behalf of her husband by selling the house to the third party. In this case, the husband have no authority to deny the wife that you are not acting on my behalf. The court upheld that Master Linton had allowed Spiro to believe Miss Linton was his agent and was therefore stopped from denying her authority to contract on his behalf. Learners, these are the ways through which an agent can be appointed or through which an agency can be created. Now, the next item we are going to look at is conditions for termination of agency. Condition for termination of agency. Learners and viewers at home, remember in our previous lesson so far, we treated law of contract. And under law of contract, we also talk about factors that may lead to the termination of a contract. factors that may lead to the termination of a contract. I want you to put it into cognizance in case of examination for those writing WAEC and NECO exams. Put it into consideration that the conditions for termination of agency and the conditions for termination of a contract are working pari passu to each other. It means that an agency has a lifespan. Let us look at this condition. Agency can be terminated on the following ground. It means the legal relationship that exists between the principal and the agent may come to an end through these methods. The relationship between the principal and the agent may come to an end through the following methods. 1, by frustration. 1, by frustration. 2, by performance. 2, by performance. 3, by breach. 3, by breach. The third one is by agreement. 4th, by agreement. The 5th one is through the death of the principal or agent. Through the death of the principal or agent. The 6th one is by operation of law. The 5th one is by operation of law. The 7th one is by completion of the agency. The 7th one is by completion of the agency. The 8th one is by insanity of either of the party. The 8th one is by insanity of either of the parties. Now, learners, we are going to look at these conditions one after the other. We are going to look at these conditions one after the other. 1, by frustration. It means an agency may come to an end through the act of frustration. Agency can be terminated when the subject matter of the agency has been destroyed or frustrated, and for which neither party is responsible. An agency can be terminated if none of the party is responsible for the termination. It could be through the acts of God. For example, learners, you order for goods and you are waiting for the delivery of such goods in your firm, and such goods happen to get damaged during the transit. It is an act that no one can question another party. Therefore, such agency must come to an end. Such agency must come to an end. Now, let's look at the second one, by performance. By performance. An agency can be terminated when the principal and the agent have performed their duties and obligations. If as a principal, you employ somebody to work on your behalf, and that person was given a particular task to carry. After performing such a particular task, definitely such an agency must come to an end. When two parties, that is, the principal and the agents, happened to perform their responsibilities or their obligations, there is no need for such an agency to continue. It means such an agency must come to an end through the acts of performance. The third one is by breach. By breach. It means an agency can be terminated through what? By breach. Agency is terminated when there is a breach of the terms of agency by either the principal or agent. When we are talking about the breach in terms of agency, it means when one of the party failed to perform his responsibilities. If the principal employs someone to work on his behalf, and the agent failed to carry his responsibility, definitely such a contract must come to an end. When the principal failed to perform his duties, as it is always required by law, definitely such a legal relationship must come to an end. Now let's look at the fourth one. That is, an agency can be terminated by what? Agreement. Agency is terminated when both parties to the agency agreement, that is, principal and agent, mutually agree to terminate it. In this case, it is different from the performance and others. It is voluntarily that the principal and the agent said, let us terminate this contract. We can no longer carry this business. We can no longer perform our obligations. Voluntarily, it is not under breach. It is not that one of the parties failed to perform his duties. But it is agreed mutually by the parties that let such business be terminated. Definitely, such an agency must come to an end. The fifth way through which agency could be terminated is through the death of the principal or agents. When any of them dies, the agency is automatically brought to an end. As a result of the death of the principal or the agents, such agreement must come to an end. Now, let's look at the sixth one, by operation of law. The sixth one is an agency can be terminated through this operation of law. The law of the country can render a trade or a service illegal if the object of agency agreement is in line with such prohibited trade or service. Therefore, it is rendered terminated when the law of the country is against a particular trade, a particular business in which the principal and the agents have agreed to carry it, to perform. Such a business must be rendered terminated, and for that purpose, an agency must come to an end. The seventh one is the insanity of either of the parties. Insanity of either of the parties. Agency is brought to an end if any of the party has mental disability. If any of the party has mental disability, it could be the principal or the agent. In this regard, that agreement must come to an end. That agency must cease to what? To exist. If the principal is insane or the agent, there is no how the two can work together anymore. Therefore, they may bring such agency to an end. Now, learners, from what we have discussed so far, that is from the beginning to the end of this lesson, the following points were discussed during the lesson. Appointment of agents or creations of agency. And this includes expressly, by necessity, by ratification, by implication, and estoppel. And we also discussed conditions that may lead to the termination of agency. And some of the conditions include by frustration, by performance, by breach, by agreements, by operation of law, by completion of the agency, and the eighth one, insanity of either of the parties. Leonard, before I step down, I would like to give you an assignment that will keep you busy at home. Therefore, pick your pen and your papers and put this assignment down. Number one, list 5 ways by which an agent can be appointed and briefly explain any tree. List 5 ways by which an agent can be appointed and briefly explain any tree. The second one is mention any 5 conditions through which agency can be terminated. Number 2, mention any 5 conditions through which agency can be terminated. If you want to read and have more knowledge on this topic, you can read the following books: Essential Commands for Senior Secondary School by O.A. Ewena. Comprehensive Commands for Senior Secondary School by A.U.A. Jensen. In case you want to submit your assignment, you can contact me through this phone number: 080-6569-4134. 080-6569-4134. I still remain my humble self, your Commands teacher, Yari Zakaria. Stay home, stay safe, keep learning. COVID-19 is real. See you in our next lesson.